Hi, everybody. Welcome to the blog today. And this was an interesting article that I read about artificial intelligence in the courtroom. So I think that when I first started my law practice, and we'll go forward a little bit. I mean, I thought I would be doing or helping organizations, with their cybersecurity and privacy issues, developing policies and procedures, and developing privacy programs, information security programs, and helping them be preventative in their efforts. Of course, that hasn't happened 2 years strong, and unfortunately, the bulk of my clients are still reactionary. The something has happened. And there's a problem, but what I didn't think that the something that would happen would be in criminal courts. And so I've had a few cases of, people acting badly and me coming in as a person that's a subject matter expert on this mobile, what a person can do in regards to sniffing networks and stuff like that. And so, what's really intriguing to me now is this idea of artificial intelligence being used to resolve cases. So, there are several things that this article was talking about. Of course, I'll post a link in the notes section, and it was specifically a conversation that happened with the New York Bar Association, talking about AI and its effects. So there's AI and legal research. Of course, legal research is essentially trying to figure out, based on precedent, what or how a court will decide a case if you argue a certain point. So, precedent, of course, is decisions, case decisions. If you present a set of facts and the court or the judge actually decides the case, that becomes precedent. So if there's a similar case that comes before that organization or before that judge, um, that particular it will go to show given precedent, that organization or that judge will respond in a certain way. So it's basically using past judicial decision. The AI part of it is using past judicial decisions based on those behaviors and outcome to predict what the court will do in a particular case. Um, the problem is, if you have a case that is based in facts, then that's okay. So, okay, no, let me back out. Let me rephrase that. If you have a case that's based on facts, that requires judgment, because what distinguishes one case from the other is the facts, right? Me speeding um, in a new sports car because I bought a new sports car is different from me speeding because I have my child in the car and I'm trying to get to the hospital. The facts of those cases are different. The judge may decide one way or another those cases differently if I got a speeding ticket forever, for instance. But in the same regard, if we're drag racing, and we both get caught, the law says speed limit is 55. We were both caught doing 85, rule based. That case is different, and I hope you guys understand that it's just a subtlety, and that's why lawyers make their money, by making those differences or arguing those differences based on either interpretation of the rule or interpretation of the facts. um but here's the thing. I think that in using AI to the problem with my problem with AI being used to determine anything is the transparency of the algorithms that are behind the technology itself. As you all are aware, if you are in the field, the cybersecurity field, a lot of the algorithms themselves aren't analyzed. So, we talked about the facial recognition algorithm with Clearview a couple blog posts ago, and no one has analyzed that particular algorithm. The reason they haven't analyzed is because the individual company says it's proprietary information. They don't have to open up the hood to have anybody do any type of analysis of whether or not the algorithm actually works or if it's not biased. And we'll get back to that because I want to talk about that. And I mean, and we can the one of the arguments that were made in this particular article about bias is that a judge will know if they're looking, for instance, they get the metrics of their court cases, they'll know if they have biases. Well, we all kind of know. Okay, so I had an opportunity to pursue a sitting on the bench to be a judge, and it was in criminal court, and basically similar to the reason why I didn't do child pornography when I was within the FBI. I know my limitations. I know my bias. If a case came before me having to do with child pornography, having to do with endangerment of a child, having to deal with abuse, child abuse, whether, if it had to deal with, danger or abusing women and things like, I already know. So it's like, I can't make the oath that in those particular cases that I will be impartial, because I already know. I have, based on my history and based on the fact that I'm a mom, I have very strong opinions about those types of scenarios and those types of situations. So I don't have to see the metrics. I mean, I already know my weaknesses. So, but I guess, theoretically speaking, a judge would, if they're leaning one way or another on a particular case, whether it's a civil case, let's say it's not criminal, it's a civil case, that it would provide them with insight. But I'm still wondering. I mean, in China, they're using these holographic judges, right? They're letting AI decide thousands of cases. And, that frightens me, because, we are already in the world, behind screens, right? We already don't have that human touch or connection, or we're moving away from it. And so now you take someone's freedom, or you take someone's, a case that's a multi-million dollar case or whatever, and you're letting AI predict what's going to happen. That scares me a lot. And I mean, getting back to the whole bias, I mean, we know, and I would be remiss if I didn't talk about diversity and inclusion, the coding of those particular algorithms, are heavily there's a lack of diversity, women and people of color that are coding those individual algorithms, that are involved with coding those individual algorithms for AI. And so you're getting one side that is actually sitting there coding, and that person believes that they're able to be biased. But it's just like me trying to code an algorithm for, someone that has abused a child. I mean, if I'm coding it, I already know the decision is, and if, are we picking that up as normal? I don't know. I think that the sentencing things. Oh, I'm sorry. There's also, just switching a little bit, there's also a technology being used called COMPAS, the Correctional Offender Management Profiling for Alternative Sanctions. So they're using COMPAS in cases to do these risk assessments to see whether or not somebody is dangerous or not. Now that freaks me out too, because of course, and as it points out in the article, right, way back when in New York, this, like I said, this was the New York summit. You had stop and frisk, right, and stop and frisk has been proven, or it went away because it was biased towards Black men. So if the algorithm itself is analyzing nationwide if stop and frisk is normal, and they look at those individual cases at the time frame that it was normal in New York, they may be normalizing that behavior and determining that this is normative, for the nation, right? So basically, COMPAS compares defendants' answers to questions and personal factors against a nationwide data group. And, as we know, I mean, I've lived in several different places in the country, right? And depending on where you live in the country, there are different things from a legal perspective, or different behaviors that exist with a more diverse culture as opposed to a less diverse culture. It's just there. And so I think the human element, the more you take the human element out of these decisions, the tougher it's going to be to say that this is fair or unfair, right? So again, there that visibility in the algorithm is a problem as well. And one of the things that the courts that the folks on the panel were talking about is that they don't want the whole deep fakes issue coming into the courtroom. But how can they stop it, right? How can they, what technologies are the courts have that's going to allow them to determine whether or not a video that's being used in evidence is actually authentic or not? Do they have the necessary education or experts that are advising them to understand what they should be looking for? And I've had an opportunity to recently speak to judges, and I'm like, how are you guys staying abreast of all of these technology changes and IoT and AI and machine learning? How are you staying abreast of these? Because they now are affecting other areas that we didn't think, just based on my law practice. We didn't think that they were coming in. We thought we were creating these things that were going to stay in the tech. Geeks, we create things. And yes, I still consider myself a geek. We create things because it's cool, but not necessarily seeing the broader implications of what we're doing in the towards society. And so it's just going to be interesting to watch. I think it's fascinating as always how technology is now in getting into spaces that I'm sure your average tech person didn't think it would get into. I didn't think, like I said, when I got out and began to start my practice, that I would be doing half of the things that I'm doing now, because technology is touching our lives in so many different ways. So just be mindful of those things, guys. Thanks again. Talk to you later. Bye-bye. Does your organization have written cybersecurity policies and procedures? If not, you may want to take a look at the cybersecurity law firm of Texas Policy Starter Pack. We may have some things out there that may interest you in your organization. One of the most interesting things that I found out when transitioning from the government to private industry is that a lot of organizations just don't write down what their policies and procedures are. And then when there's some type of incident, they have a hard time proving that they were being reasonable in their approach. So please take a look at our starter pack, and if there's anything we can help you with, let us know. Random thought for the day. I'm going to stay on the legal side of things. So there was an interesting case where an insurance company actually had to pay their client for their ransomware attack. So, State Auto Property and Casualty Insurance Company out of Ohio will have to pay National Ink and Stitch, which is a Maryland screen printing business, after they had a 2016 ransomware attack that essentially left their server that had all of their IP on it, intellectual property, and all of the information on it. They left it. It was left useless. Okay, so he got hit with ransomware. They paid. Hackers wanted more money. They didn't disclose how much money. Hackers, of course, wanted more money. I don't know if they paid the second time or not, but they had to hire a forensic company to come in and clean it all up after that second time, I think. And so they weren't able to get back up to full functionality, and the insurance company denied the ransomware claim, this time saying that they didn't have direct physical loss or damage. The court decided this on summary judgment. What that means, summary judgment means, is that the judge didn't even hear the case in regards to the arguments or whatever. The judge read the case. The facts were indisputed. The judge basically said that physical loss or damage does not mean the way that the insurance company was reading physical loss or damage is saying that because that the screen printing company was able to get some functionality out of it, they weren't required to pay the claim. And the judge was like, no, 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 no. That's not the case. That's not what case law says. That the policy doesn't read that way. So they forced them to actually pay. They didn't disclose how much that the insurance company was going to have to pay. But the point is, the more of these cases that happen, now we all know insurance companies don't want to pay claims, but the more these cases happen, the more the courts are going to get educated on how some of these attacks work, and the less likely that they're going to be able to continue. Insurance companies are going to be able to continue to deny some of these claims based on these obscure languages in the policy and things like that. So it's going to be interesting to watch as always. All right, guys, have a good one. Thanks again for listening to the Breach Whisperer blog, sponsored by the cybersecurity law firm of Texas. Don't forget to like this post and subscribe to our channel so you can get updates of when we post new things on our channel. In addition, spread the word for me, right? Let's get out there and tell a friend, and so they can all become paranoid cybersecurity and privacy people. Don't forget, if you would like to connect with me on socials, you can connect with me on Twitter. At Mary N. Chaney. Use my middle initial always. For my nonprofit, Minorities in Cybersecurity, that is at Mike Leadership. And Instagram and Facebook at MN Chaney Law. And you can find me on LinkedIn just by searching for my name. So if you're interested, connect with me. Thanks again. And just remember, awareness equals knowledge.